My dear friends, I'm very happy to congratulate you on this Jubilee year. After so many years of hard work, your institute has reached high. It turned into a center with authority. Its current team is actively engaged with the Russian Academy of Science, and it always takes part in the most important tasks of the country. This institute, and which is a great luck for the institute itself and for the country, combines two important sides. It has a great scientific potential with practical doctrines, and they're also famous for introducing those doctrines into practice. Let them be healthy and let them be prosperous, and when the next milestone is going to be reached, I hope that our descendants will say a lot of kind words for the Institute. I believe this Institute must be a permanent organization in this country. Without it, I think it's hard to imagine the country going forward. And all of them are taking an active role in all of our legislative activities. All the draft laws are being checked and audited by the Institute. All the recommendations they make and all the proposals they introduce are definitely taken into account, and they make our bills ever so richer. I think it's a great thing to do, and I think it's a good thing to do, because in this way we see a great collaboration between the legislative system of Russia and a prestigious institute. It's one of the key center of legal culture in Russia. It cherishes and preserves our local traditions. It has unique scientific approaches. Its scientific members have participated in developing the legal system of Russia. Our members are partnering with the colleagues of the Institute, and this collaboration is very fruitful. And let me use this opportunity and congratulate the management with the 100 years anniversary and all the team in the organization. Let me wish them a lot of professional success, more scientific advancements, happiness and wealth. I would like to congratulate all the members of the Institute with the 100 years anniversary. I would like to thank you for a great contribution you made to strengthening our legal system and for the work you do so diligently. The books of your scientists have seen many generations of students. This institute not only brings together historical traditions, but all the new trends as well, across different subjects of law. And for 100 years, the institute has many friends, both in Russia and abroad. We know that the institute, headed by an esteemed academician, Ms. Khabrieva, in our Eurasian space, serves as the main scientific hub. Tavria Khabrieva is a great backbone of this institution, and she serves as a bridge between the Azerbaijani Academy of Science and the Russian Academy of Science. The Institute of Comparative Law Science is an important partner of Bedun Academy and our good old friend. In this 100 years anniversary, let me wish for our friendship to continue for many generations to come. On behalf of the School of Law and the Center for Russian Law of the Halo-Jiang University, congratulate the Institute of Legislation and Comparative Law with a 100 years anniversary. The works of many famous scientists of this institute positively impacted the process of legal system development in China. On behalf of the Institute of Law and International Law at the Chinese Academy of Public Science, I would like to wish your institute more achievements in its further activities and strengthening Russian-Chinese links in jurisprudence. Allow me, on behalf of the Committee on Human Rights at the President of Kazakhstan, and on behalf of all the lawyers at the Bar of Kazakhstan, congratulate the Institute of Legislation and Comparative Law under the government of Russian Federation with this amazing jubilee. The Institute, for many decades, have built a reputation for itself. It has a proven track record as an institution with the highest expertise. When I was awarded an honorary professorship, I said it back then and I repeat it now again. Everything that depends on me to see the institute growing, to see its potential growing, and in any other matters, I will do what it takes to make it thrive. The St. Petersburg University and the Institute of Legislation and Comparative Law has long been good and solid partners. Thanks to our joint work with Talia Khabrieva, an honorary doctor of the St. Petersburg State University, we manage to deliver large-scale scientific and educational projects. We find new ways towards our research. It's hard to overestimate and exaggerate the role that the Institute is now playing in our state, in the matters of the state. Let me thank the Institute, who is turning 100 years this year with this amazing jubilee. You're doing a great job, you're real professionals, and let me wish you all the success. Living on this earth requires to stay within the legal field, following the rules of the game, and the more modern are those rules, the easier it is for us. This institute is an amazing institution, first class, top-notch, and they've been leaders across many tracks. And in the time that the institute was growing, they have developed a lot of interesting infrastructure, but the most important are the scientists that work in there, because I'm sure that all the treasures need to be passed on to the young generation. This institute we have connections with because we exchange staff. Many graduates of our Kazan University have gone through master degrees and postdoctorate degrees programs at the institute, and I defended their works in there. This institute, for us as an institution that trains lawyers, serves as a flagship, a leader of legal science in our country. And this is one organization that we look up to. We follow in their tracks. Today you have accumulated public authority and you've deserved your recognition. Within the walls of this institute you have the flower of the legal science, local legal science. You have the stars, you have the gurus, you have the well-recognized and renowned scientists, and of course talented youngsters. You're really a forgery of new talents. And everyone who graduated from it brought a lot of answers to the most challenging questions of their times. And I have no doubt that this is the way it will continue. 100 years, for me, is a landmark event. Using the knowledge that the Institute has, we can achieve a lot, and I believe that they have a lot of weight. What I would like to wish to you, dear friends, is success, well-being, and of course a lot of health. And also, I would like to wish you, to your university, to your institute that celebrates 100 years, have lived to celebrate 250 and more years to come. And we want to bear witness of all those celebrations in the years to come.
Having watched this series of very pleasant videos, I'm glad to welcome you at the International Practice School of Young Legal Scientists, Youth and the Law. This year, our Institute of Legislation and Comparative Law marks a special milestone, its centenary. For almost 2 decades out of this 100 years, we have been convening such practice schools for the youth. It's not the first time that this forum is being held at the heart of innovation in Russia, Skolkovo. We appreciate our partners, Skolkovo, and personally Mr. Shuvalov and Mr. Drozdov. Thank you for that. Let me remind you that this is a renewed tradition. In the past era, it was very popular and very useful. Time has shown that such practice calls are very impactful. I think that our initiative can become a facilitator for dialogue between different generations of lawyers. That is something that we need to work on if our scientists, science and country are to have a future. Our practice calls always focus on things that are relevant for younger people. In this anniversary year, we decided to bring to the fore the main idea of these practice calls, encapsulated in its motto, which is the schools are for young people, with young people, and about young people. I think you would agree that this is most relevant, keeping in mind that we have an ongoing constitutional revamp. The legislation on the youth policy in Russia is being elaborated, as well as a major fundamental reform in the education system that was proclaimed by the president this year. Do we have the capabilities to address these major global challenges? I think we have, and we have great experience to show for it, accumulated throughout the years of our existence. We have great partners, and most importantly, we are able to deliberate these issues on a high conceptual level. Our faculty has a lot of young people as well. Out of the 200 academic researchers, a quarter are younger people. Of course, this is driven by the CNM-metric indicators that are important in our evaluation, but there is more than that. We are doing a lot to enable growth and development of younger people. What's most important, though, is to ensure continuity, that there are new generations of legal scholars to replace us. This has always been a cornerstone for the institution and the scientists that have served it. Then it is also important to remember that when we are speaking about continuity and traditions, one ought to put some effort into designing new traditions, which is impossible without the inputs by younger people. Our institute has fostered an environment to accommodate this, and you'll be able to learn all about it if you get to know the institute closer. On top of that, a lot of scholars in our ranks have made a lifelong commitment to the institute. They joined us when they were relatively young in terms of academic age, and then they've dedicated their life to the ideas of justice and law. You can learn more about it in our chronicle that we have been compiling with great attention and care. We are about to issue the 5th edition in 5 volumes now, covering our scientific schools as well. And then there is more. Upcoming, there are panel discussions joined by our research leaders. Then, as always, we'll have a dedicated panel on a legendary figure in legal sciences. This time it's Yuri Nozdrachov, who joined our institute as a postgraduate student and has dedicated his life to our institution. There are many other examples like that. There are even dynasties. Albert Pigolkin, for example, a great theoretician of the law, spent his entire life at the institute, and then he passed the baton to his daughter. Our institute sometimes serves as a platform to start a family, so people continue discussing and debating legal matters at home as well. Another telltale sign of a creative atmosphere, which is very important to maintain at an institute. We don't often speak about mathematicians, but once at an executive board meeting of the Russian Academy of Sciences, I came across a quote by a great mathematician, Vasily Nalimov, the founder of Russian cynometry, who said that it's not all about the figures in the end. It's actually about the emotional state of the researcher that determines the outcome. High emotions are typical of the youth, and we keep that in mind, trying to leverage that. I think this is one of the drivers behind this great output by our younger researchers. You know, seeing the publications by the group of 13. Our young researchers are able to reach out to the leaders in the academia to speak on equal terms with them, get feedback, use them as sounding boards, and then they step up to the challenges that would be daunting for many a scientific collective. But younger people are driven by the examples that they look up to. Take Yuri Tikhomirov, who actually founded this group of 13. It's grown by now, of course. And just look at their publications. Marvelous work, showing that young people have every opportunity at our institute to carry out research and then actually have an avenue to translate them into practice. To develop younger people at the institute, we have 8 master's programs, and current number of students is 212. Just as many we have in postgrad studies across every domain of law. And there are very few institutions that have this approach to discussions. First, it's one-on-one, because we are all about bespoke instruction. Very few institutions can boast availability of such figures as Professor Kovler, former judge of the European Court of Human Rights, or Professor Gadjiev, or Professor Kapustin, president of the Russian chapter of the International Law Association. I think that such opportunities are very important, in particular, in order to form your vision for the future. This slide shows legal scholars and statesmen who wrote their thesis at our institute. The list goes on. It's just a sampling for you to get an idea of what stands behind my words. This is indeed our purpose, and I hope that our practice school that we're having now will advance it. Speaking directly to the opportunities for the youth, I think we have much more to offer when there is a standard program for masters or postgraduate students. We have a young researcher endowment, for example. There are ongoing competitions in this regard. We have employer-supported postgrad studies. We are thankful to our Board of Trustees who issue dedicated personal scholarships for students and postgrad students. Most importantly, we give access to master students, postgrad students, and young researchers to participate in working on most important real-life state assignments. A while back, Skolkovo approached us with the idea to draft a concept for governance of the digital economy. Our young researchers contributed to that, and I think this is quite telling. In closing, I would like to quote Professor Polyanskaya. She had worked at our institute for over 4 decades, and she is one of the contributors to our chronicle as well. She gave a very apt description to our success and its constituent factors, saying that the faculty perceive their jobs not as a public office, but as service. So our institution is a true corporation bound by firm ethical beliefs and dedication and commitment to law. With that, thank you, and I'd like to give the floor to Mr. Shuvalov. You've just seen him in the slide, so happy to see you with us again. Thank you, Ms. Khambrieva. Let me join in on the congratulations on this milestone. The Institute of Legislation and Comparative Law is a very important institution for us. Just imagine what it's been through and what its experience has been over its century in operation. The Institute was developing together with the country through its rough patches in the 30s, ups and downs, for example, as far as being on the brink of being dissolved. Yet, 100 years is a milestone for you personally and for the entire faculty, existing students and future students of all levels. Congratulate you on your achievements, including your personal contribution. Over the past few years, a lot has been gained under your leadership, so congratulate you as well. But my role here is to represent Skolkovo. This international practice school is co-hosted by the Institute and by the Skolkovo Innovation Fund. I am authorized to greet you on behalf of Skolkovo. Mr. Drozdov is going to make a presentation, so I'm stepping in for him. Today I'd like to speak broadly on two aspects of legal education, following on what I was speaking about last year. Yesterday there was a meeting of the Executive Board, chaired by the President, Executive Board of the State Council, which considered the matters of technology development and technological sovereignty. In this regard, I'd like to highlight the role of lawyers and legal scholars. Skolkovo, even sometimes called the bigger Skolkovo, runs three schools. The New Economic School, founded by academician Makarov, who is a mathematician, by the way. And if I may say so, this is the best private economic educational institution. Its bachelor program is run together with the HSC. The master's program is carried out on its own. They're actually developing. The chair of the board there is Mr. Kudrin, and the curriculum there is tough. The graduates are top-notch experts. And best international colleges and universities enroll the graduates of the New Economic School eagerly. The second school, which I'm a part of at Skolkovo, is Skoltech. It's a new school, it's younger than the New Economic School, but it's made great progress. It's been widely recognized, and its diploma is quite unique. Currently, we are working together with the government of Moscow and the federal government how to launch a bachelor program at Skoltech. It's high time we did that. So hopefully, we will see first bachelor students at Skoltech pretty soon. The third school is Moscow School of Management at Skolkovo. You've heard about it, they run a lot of programs. At the center of their curricula is training MBAs, but by now they have already rolled out short-term CPD courses and a host of other programs. I mentioned them last because they too have a bachelor's program now. It's very interesting. They enrolled their first 25 students in 2022 out of the students who applied to the Moscow Institute of Physics and Technology. Well, obviously, you need to be strong in maths and physics to apply there. But then there was a group representing Moscow School of Management from Skolkovo. They suggested that there is a joint bachelor program together with the Moscow Institute of Physics and Technology to teach students management, and people split their time between two campuses. So in 2022, they enrolled 25 students to pilot this program. I met them. They are all outstanding. As we discussed it with Mr. Voloshin and other colleagues from the School of Management, we kind of broached the idea of launching a bachelor's program in legal studies, which brings me to what was mentioned yesterday at the executive board of the State Council and how the president perceived that. There were proposals to change the approaches to the single state exam. And if someone is not as good in STEM, they would still have an opportunity to enroll in a technical university. People say often that economists and lawyers shy away from STEM, but living in the age of high tech, there might emerge a gap between engineers and lawyers who set up the legal frameworks to develop and protect their intellectual property. The president said that there need to be opportunities for all-round development of personality. You can look up the speech, and he mentioned that he knew personally people who succeeded on the humanities track, but then wrote a doctoral thesis in mathematics. So my call upon you today, to seniors, to people my age, researchers or practitioners, and especially to younger people, is that we need to master this, because it's a key part of our future success. Because just studying the law is not always enough for an innovative economy. You need to be on the same page with engineers, people who advance the technology, who study STEM. In this regard, the agenda of the technological sovereignty has taken on a new meaning. As you'd recall, there were a lot of discussions about input substitution. It's been on the top of the agenda since 2014. Since last year, when the special military operation started, Mr. Medvedev proposed this term, technological sovereignty. And unless we work together with the engineers and product makers as legal scholars, this would just not be possible, again, unless we work together. An outdated concept of a lawyer as a backward conservative who tries to protect and keep in place obsolete economic relations, closed to anything new, is a thing of the past. Lawyers ensure continuity. This is the bit where conservative is useful, but without fresh blood, without knowledge of engineering, among you who are researchers and are aware of digitalization or environment, this would not be possible. So, Ms. Khabrieva, I'm aware that your institute is working on this, involving younger generations, older researchers as well. With academician Makarov, for example, and his team, we'll be looking at the opportunities on the side of Skolkovo, the institute, and your institute to use mathematical models, cognitive computing, and big data to merge them into something that should drive the development of public and social relations. I think there is a lot of ground to cover, working together. We are already agreeing on a date for our meeting, so I invite younger people to participate as well, participate in this partnership. You have my assistant here, you can take the details from them. The meeting will take place at Web City Labs. We'll be looking at potential joint programs by Skolkovo Schools, Institute of Physics and Technology, and we invite you, Ms. Khabrieva, to take part as well. The basic product will be provided by mathematicians, though, because they have the models that can identify the most vulnerable parts of our economic development so that we can focus our capital infusions on that in order to fill the gaps or drive breakthrough development. Development institutions, including WEB, have plenty of capital to finance all the projects that are on the table. There are less projects to choose from currently than the capital that we have at our disposal. Great ideas are good, but in order to provide funding, this is not enough. It needs to be a well-worked-through project with initiators, documentation, and entrepreneurs, whom we'll be banking on as key partners. These are the conditions for funding. But once again, WEB, commercial banks, the Russian Expert Center, the SME Corporation, altogether have more capital than the list of projects that are out there as candidates. And I think that legal will play a major role in this, in terms of drafting project documentation, presenting it properly, and then maintaining the product until completion. Not to take too much time, I'd like to welcome you all once again, congratulate you on your centenary. Thank you for hosting this 18th practice school. I hope that we'll take some of the ideas offline and push for results to have something to present next year. Thank you. Thank you, Mr. Shuvalov. As always, we are open to any new partnership or extension of partnership, especially with Skolkovo or with the new economic school. And we are not daunted by any challenge. I thought of an example from our history, from the 1930s, at the heat of the repressions. The faculty was only 25 professors, 25 junior research assistants, who were tasked with preparing textbooks for all legal disciplines, while the main specialization at the time was criminal law. Under 2 years, they prepared 6 handbooks for legal schools and then 17 textbooks for universities. In the second run, by the 1950s, they prepared more than 50 textbooks. And the backbone of the faculty at that time were scholars who trained and worked at the Tsarist Russia. So this was tricky for them. As for new subjects that are not really a surprise because technology is advancing steadily, we have experience in that, and we do not shy away from mathematics either. We still have at our institute, as part-time worker, Mr. Bakhtin, Makarov's student, a correspondence member of Russian Academy of Sciences. 15 years ago, we used their mathematical models for a study that we named a concept for the financial security of Russia. It was used by the Financial Monitoring Service, where with Mr. Chukhanjin and Mr. Makarov, we presented it at the Executive Committee of the Russian Academy of Sciences. So we have this type of experience. Of course, some people are not as friendly with mathematics, but I think that the new generation of lawyers will be up to the challenge. There are examples where mathematicians switched gears and began studying different subjects, including at our institutes. And I think the best research works come from people who used to be in STEM, just like in philosophy. I had an idea, since we began poaching candidates from Institute of Physics and Technology to Skolkovo, I think we need to reach out to other top universities in Moscow and start a program to then officially invite them to Skolkovo, to the legal school soon to be established. We are ready to contribute and participate. Thank you for this idea. Colleagues, we've decided to shuffle up our format for this year. Mr. Shvalov proposed that we do not go with opening remarks and reports, but rather focus on dialogue. We have a panel of speakers, and for the first time ever, the panels will be moderated by our younger colleague, a head of the research unit, Pavel Kabedov, a PhD, so handing over the reins to young blood. Esteemed Ms. Khabrieva and Mr. Shvalov, thank you very much for the opportunity. Indeed, it's a new format for us, including for me personally, so apologies for being a bit anxious, maybe. The headline topic this year is indeed very relevant: youth and the law. It's mainstream for many reasons. For many centuries now, it's been said that younger people drive the progress. I'm also glad to note that this practice school of young legal scientists is garnering wide attention from the society at large. As was mentioned, we got a lot of welcoming remarks and congratulation notes. It's available on the school website. On this high note, I'd like to invite our speakers on stage. Successful and renowned practitioners and theoreticians of law who have gained and secured their position in the lead of our profession. I invite on stage Igor Drozdov, chairman of the board of directors, Skolkovo Foundation, PhD in law. Tatiana Kuzmina, first vice president, head of legal department of Gazprom Bank. Roman Yankovsky, deputy dean of the law department at High School of Economics, PhD in law. And Arseniy Sheltsin, director general of digital platforms, an autonomous non-profit. Dear colleagues, your attendance today, the experience that you bring with you, and the knowledge that you have are invaluable for young lawyers. Back then, when I was a student, I treasured such events where you could approach the old-timers and renowned experts in the profession. It is something that drives you to develop and to grow over yourself. Again, it's a new format. We suggested that the participants submit their questions ahead of time, and we received quite a lot. We tried to process them so that there are some rubrics to our discussion. And the first one can be titled as the link between theory and practice. It's been debated for centuries, there are different approaches to it, but I think the most apt thing to say would be that without practice, theory is useless, while without theory, practice is blind. So my first question goes to you, Mr. Drozdov. It's well known that Skolkovo opens up a lot of new opportunities for younger people through unique partnership formats and education formats. How would you assess the activity of young people and their contribution to addressing the most pressing issues in legal studies? Oh, apologies, I might have misspoke. I was distracted by the flash. Apologies once again. Mr. Drozdov, it's well known that you have fundamental experience in building young teams, as was mentioned by Ms. Habrieva. And together with the Institute, you carried out fundamental research and applied research when it came to developing the concept in 2020 and 2021 for the newly established digital economy. Well, Skolkovo, as the center of innovations, attracts a lot of young people. Mostly, this has to do with engineering creativity, because these are people building companies, advancing technologies. They hire lawyers as well, but this is more or less secondary for them. But then again, given the experience that we have at Skolkovo, given the knowledge that we gain from startups that we host, looking at their needs, we have been, for a few years, assisting the professional community and the state in building the legislation for the digital transformation in the economy. Ms. Habrieva mentioned that assignment that was taken up by the Institute, and indeed it was part of this effort. Several dozens of bills and implementing regulations were drafted by our Center of Excellence in Digital Economy. And people who worked there were lawyers, albeit with experience of working at innovative companies, so that they have first-hand understanding of how technologies evolve, how they work, and how the process of progress can be framed with the law. Thank you very much for this response. My next question is to you again. I think it's especially relevant now. Recently, a lot of international partners have been denying to deal with us, including in academic partnerships and cooperation, although not all have rejected this work. The question is this: is there any deliberate effort to set up academic ties with friendly regions, like Africa, for example, because there are advanced economies there as well, Southeast Asia, Latin America, and other such regions? Can the legal science contribute in any way to make these contacts more effective? Speaking about academic contacts, I think it's a question to Skoltech more than me. I know that they are working on it, reaching out to the countries that you mentioned. Speaking about our technology companies, our priority has been China and India recently. These are potentially large sales market for Russian companies, as well as actually a huge market where technologies that we are lacking can be procured. To make this exchange effective, you need to be well versed in the legal systems of these countries. If you speak about international private law, it's been the custom, at least when I was a student, to focus on the Western European and Anglo-Saxon legal systems. Now, I think it's more than reasonable to start studying the approaches that are out there in China and in India. Naturally, they have absorbed some of the norms from the aforementioned legal systems that essentially succeeded the Roman law. But then there are a lot of local features specific to them, and to be successful in these countries, you need to be well aware of that. There is an example in technology, for example, that I can give you. I can tell you about personal data protection. as the European, the American, and the Chinese approaches are dramatically different. The reason for that is the philosophy that informs the legal systems in these countries, their attitude to invasion of privacy, the ratio between privacy and common good, and their view on acceptable risks in security. I think in such cases you need to study these legal systems very closely. Now on to AI. There's been a lot of news recently, and there are very different approaches here. There are newly emerging chatbots like ChatGPT 3 and 4, and there are countries already who are or have restricted access to these chats. In Europe, I think in Italy, it's been banned. Germany is considering it. And it's not about the menace of AI, as is. The rationale that was given was that these chatbots violate personal data protections of the users. So the logic actually goes back to the fundamental approaches to protection of personal data accepted in Europe. And as you are developing a technology and implementing it, you need to anticipate how any given country would react based by their approach to technology regulation. Mr. Drozdov, you mentioned AI. I think that indeed this is one of the most pressing topics of the day. There are a lot of breakthroughs there that we are witnessing, like ChatGPT and other language models. What has Skolkovo been able to achieve here? If I may, I'd like to make a brief report, actually, on AI and creativity. I think it would be more informative than me commenting on the news. Well, it's a very relevant topic, so welcome. Thank you. I wanted to talk to you about AI and creativity today. There are no legal terms in the name of my speech, but I think that it's related closely to law. Speaking about creativity, lawyers usually first think about intellectual property, because IP protections apply to products of creative activity. So, when we're talking AI, lawyers first think about IP. I believe there are both technical and legal aspects to it. But what is creativity in the first place? Habitually, this is something to do with music, acting, painting. But legal scholars also speak about engineering creativity or technical creativity. Inventors and scientists are creative. They come up with something new. And there is a term for this, technical creativity. But then, how do you differentiate something creative from something not creative? Generally, creativity is our outward expression. We have our cognitive features, we have the background of learning, our experience, exposure to information. And when we express ourselves, this is by definition creative. Even if someone believes that our output is mediocre, if not horrific, it is still creative, regardless of its social evaluation. In other words, creativity is an expression of our own personality. While if you repeat things after other people, you are just copying what has been done. In technical or engineering creativity, there's been a host of tools or technical means to accomplish this. We've made great progress from a stone hatchet to complicated industrial equipment. But then you have technologies that enable thought creativity as well. One telling example here is the emergence of photography 200 years ago. At the outset, it used to be very technical. It's not like using your iPhone. You needed to be skilled at lighting, photochemicals, and such. And people debated whether photography is creative, like thought creativity or technical creativity. But the ruling was made overall towards thought creativity. Look at this picture of Albert Einstein. A true work of art. Just like a painting, it's not a mere record of reality. It's an expression of emotion, and expression or manifestation of a creative idea. The human contribution into production of creative output has been diminishing in both aspects of creativity, technical and thought creativity. The law provides that, well, it's actually derived from the law and it's codified in the resolution by the plenum of the Supreme Court that if something was created without human input, it's not protected as IP. And then, as AI comes to do everything instead of man, you need to think carefully whether it's IP or not. Originally, AI was used as a tool. There was no novel output from AI. Here are a couple examples. Here is a picture by Pablo Picasso, Blind Man Meal, it's to the left. But then scientists found another painting layered under this one. X-ray imaging revealed that picture, and then AI recreated it meticulously. The texture, the coloring, the brushwork, all replicated precisely with AI. When Pablo Picasso used to be poor, he painted over his previous paintings because he couldn't afford new canvases. And this other picture, hidden below, was recreated. But who holds the copyright? The scientist who recreated it or Pablo Picasso? Well, probably the latter, because the former didn't think about the concept. And then you have Beethoven, who wrote 9 symphonies. The 10th was uncompleted, they were scribbled illegibly, people tried to recreate it. But only AI succeeded in that. The same concept applies. AI wasn't used to come up with something new, but rather it was used to restore access to heritage. And then there are more recent examples. You've probably heard of Getty Images, an image bank. Then Stable Diffusion generated these pictures based on Getty Images. The pictures on there. Getty Images sued, and after the litigation, there is a watermark placed on these pictures because they've protected their rights to be named as the originator, even if it was generated by AI. But at its current state, AI can do more than replicate or copy. It now can replicate the thought process or the style. Just take pulp fiction detectives, a bunch of them by an author, and the AI could come up with new pieces in that style. It's not transformation per se. It's a new piece because it operates on a high level of style. I think we need to start considering a new type of use. It's not in the law, but I think we'll get there. Use of copyrighted materials in training of AI in order to create new IPs. And in the law, it should provide that you need the copyright holder's consent, especially if it's intended for commercial use. In technical or engineering creativity, there are a lot of useful applications of AI as well. Let me talk through just two examples from the slide. The Chinese army designed the power systems for a new military ship 300 times faster than it would take a department of human engineers. Then, NASA designed these cantilever fixtures from scratch using AI, top to bottom. So those who have advanced hardware gain a competitive edge, whereas previously intellectual property rights incentivized people for their wit and skill. They could protect their rights, get a monopoly, and enjoy the benefits. Now, the advantage is with those who have better hardware and software. Those parties who hold them would be, by default, much more powerful than a most clever inventor. So those in power gain more power, and people who are weak become weaker, exacerbating the inequality. In thought creativity, I found an example in A Dystopia by Evgeny Zamyatin, titled We. It was written in the 1920s, and it foresaw a digital world, fully subject to mathematics. The protagonist there went to different lectures. Here is what he recalls. I succeeded with difficulty in switching my attention in again when the formal lecturer came to the main theme of the evening, to our music as a mathematical composition. Mathematics is the cause, music is the effect. The formal lecturer began the description of the recently invented musicometer. By merely rotating this handle, anyone is enabled to produce about 3 sonatas per hour. It was written 100 years ago. Now I think you can churn out 3 sonatas even faster, enabled by AI. His forecast was much later in time. Here are 2 examples. The Crow, the first fully AI-generated short film. It was awarded at the Cannes Festival. And there are a lot of books generated by ChatGPT. There are 200 of those available on Amazon as of February 2023. But who holds the rights? Because the minimum standard is there is a human contribution, hence the owner. Otherwise, it's not possessed by anyone. There is an example from the Supreme Court of Russia. I told it to my international colleagues, and they were surprised about how advanced we were. The example is simple. There is a traffic camera. If it records a violation, this image is not protected because there is no creative contribution and there is no creative concept. It's a mere record of reality. But it's not as straightforward, actually. AI, in the state that it is now, doesn't generate anything on its own. It needs to be prompted. If you've played around with ChatGPT, you'd know that the quality of your prompts would determine the quality of output. If you're generic, the answers are primitive and generic, but then you can make a deep dive and the responses would be better. There was this widely publicized example where a student wrote a thesis paper with ChatGPT, but their human contribution was in the form of the prompts. I think that merits to be called a creative output because it determines the output. So you cannot squarely say that AI works on its own. But then I'd like to give you a very specific example still. An invention needs to qualify in terms of novelty, industrial feasibility, and the level of invention. The level of invention is something that's not obvious to an expert given the state of the art. That's the cantilever mount that NASA designed. Inconceivable to a human mind. Not possible to design. So there is a level of invention. It's patentable. And math engineers wouldn't be able to do that without AI, right? So I think that we need to review our approach to evaluation of the level of invention. We need to evaluate the prompt fed to AI as well. If the prompt was trivial, this shouldn't be protected as an IP. Otherwise, we would be given unfair advantage to people with smart machines. If the prompt was complex, merited a certain level of invention, then this in turn merits protection. Let's look at other predictions as well. Do they actually come true? If I may indulge myself, I'd like to refer to the Strugatsky brothers. In 1963, they wrote The Far Rainbow, a planet where people experimented. So people spoke about the Massachusetts machine, a supercomputer that turned out self-aware, and it worked exactly for 5 minutes. It was phenomenally high performance, it had broad memory, but then they unplugged it, cemented up all the entrances and exits, diverted all the power sources away from it, landmines around it, and put up barbed wire. It was terrifying. It began behaving. So here we can get a glimpse of obstacles to come in the development of AI, because already now, Wozniak and Musk, for example, call for a halt on development of ChatGPT. In Italy and Germany, they want to curb it, and people go as far as suggesting that missiles should be launched at the sites where AI is further developed. So I think the future of AI is quite complicated. We'll see. I think the Strugatsky brothers envisaged that this would happen in the 22nd or 23rd century. So we got there quite a bit faster. It's my third time that I present at the practice school. I've never spoken about AI, and people often ask whether it's a legal person. What does this mean? The law is there to regulate relations between people and to govern their behavior in order for people to group together into larger communities. Noel Harari speaks about monkeys who are quite clever, but they can group up to 50, no more, because the sounds with which they communicate only support that larger group. As humans, we have language. And then, on top of that, you need rules that come in the form of the law to organize even larger groups. Enforcement may vary, self-organization or the state, but still, there are the rules. We need them in order for us to feel comfortable. That's for our survival, to put it bluntly, because we will not survive as successfully in chaos. So the sole beneficiary of the law at this time is the humans. So it's evident AI is not a legal person. But if we decide for some reason that AI is entitled to some benefits under the law, if we need to take care of their life or whatever it's called, this might be revised. But I don't see any grounds for this at this point. I think that Earth is destined to the humankind, and we are the only beneficiary of this order. So AI cannot be a legal agent. Thank you. Thank you. Let's hope that the Terminator movies would not come true either. Ms. Kuzmina, a question to you. It's a compound question. It's quite unorthodox, but still. What's the main criterion in selecting your specialization in the legal profession for young professionals? How do you create a conducive environment for their growth and development? Is there an optimal balance between theory and practice? Thank you for this question. Indeed, it is something that we face on a daily basis in our operations, where we need to leverage fundamental knowledge, scientific knowledge, to advance our projects. Let me start, however, from the very beginning. I'd like to first address the point on our work with the younger generation and our contribution to their growth and development. Our bank partners with over 150 colleges and universities. We offer scholarships as well, and we participated in a number of programs that were set up at St. Petersburg University, at Moscow University of International Affairs, and in Tomsk. Closer to the ground, at our legal department, around 40% of lawyers are under 35 years of age. We have internship programs as well. And we have this established approach that even the most critical jobs can be offered to younger professionals, starting from recent graduates or even students of the 4th or 5th year. They get assigned a mentor and gain access to immersive opportunities to develop into a unique, specialized lawyer after 4 to 5 years. Now, on to the way we combine technologies, law, and science, including technical sciences. As the legal department, we are making an effort to automate and digitize our processes. Many lawyers used to think that their judgment cannot be reduced to an algorithm, because you need to take a lot of decisions as you assess something. But there are routine processes, for example, some legal reviews that need to go through with a methodology, get automated with checklists. All the e-documents are already there to be reviewed. The step-by-step process of the review is designed into the algorithms. And these systems even have access to external sources of information in order to come up with a determination. For example, we review such things as legal capacity and authorities, different reviews for opening of accounts, and lawyers, in this sense, become methodologists who design these automated algorithms. And then it's rolled out to the entire network of our banks. Sometimes basic things can be automated and handed over for supervision to non-lawyers, while we, as professionals, as legal professionals, can focus on creativity, believe it or not. We focus more on structuring the deals. We get involved in development of new products. And I can give you an example of how science comes into play here. Currently, there is a project to start issuing digital rubles. The job of lawyers here is to define the legal nature of this entity and integrate it into the existing civil law framework. Then again, only recently, Gazprom Bank participated in setting up a registry of carbon units. First such units were already emitted. These are basically assets that derive or originate from implementing a climate project. The law on GHG emissions provides for such carbon units, but their legal status is not fully defined yet. And here we can refer to academic research in order to inform our approaches to these entities. Because are those marketable securities or are those assets where you can exercise property rights and such? Because it'll have a lot of implications for trading such units or for segregation of responsibilities, obligations, and liability. This is something that we are faced with every day in our day-to-day operations. There are some unique national projects. I've given you a couple of examples. But then there are bank-level projects where lawyers need to be quite creative to assemble new products from what's available in the legal domain. This issue of creativity in the legal profession is controversial. There is a conflict inherent to it. Lawyers are guided by the law. The source of their work is the rules. Where you have clearly defined rules and procedures, there seems to be no space for creativity. It can be dangerous sometimes if you speak about, let's say, creative lawyering. But I have good news for you. There is actually space for creativity. The rules are there, but you are here to assemble them into something new. And then there are always new subjects to be regulated in our projects or on the national level. For example, we contribute to public consultations on draft bills, which is indeed very creative. For example, I'd like to mention that our bank has committed to the ESG principles or sustainable development principles, where you undertake environmental stewardship, social responsibility, and high standards of governance. Along these lines, we have created a number of new products. Green bonds, for example. This is the type of bond where the funds raised are then directed towards environmental goals, reduction of emissions, and so on. Thank you. Very interesting. Indeed, there is a lot of food for thought and a lot of jobs to be done by younger people. Colleagues, if I may, let's change tack. Since our time is limited, we'll switch to a lightning round of sorts. Quick back and forth, 1 or 2 minutes per a response. I think it's liven up our discussion as well. Mr. Yankovsky, the first question goes to you. What's the scope and limits of applying new technologies in the legal profession, including AI? I think it's one of the more pertinent issues in the legal community, whether they're going to survive as a profession. At the High School of Economics and the consultancies with whom I work and communicate have been using new technologies extensively. Just yesterday, we had a meetup on GPT-4. We met with Russian startups who have already integrated it into their products using the Open API. A major problem here is, of course, that OpenAI, the company, has joined sanctions, and their license agreement says that they do not offer services to companies who are registered in the sanctioned jurisdictions. So companies are cautious of integrating it into their products. If the access is cut off, the functionality would be impeded. So we are looking forward to Russian companies who have announced it, like Sberbank, Yandex, and Skolkovo, mentioned it a number of times. Looking forward to the Russian companies to come up with Russian products with similar functionality, APIs, and plugins. In the legal profession, it's more than applicable, as well as in education. Yet, we want to be guaranteed that these products will remain available and that the data that you upload there, including legal and sensitive data, are stored appropriately and there is clarity on how they are processed. As regards education, I think it's also important that the data stays in Russia. My next question goes to Mr. Shelton. In light of the sanctions, how do you see the trends in regulation of IT? And given the need to protect our market, how does the change in the relations between the tech giants in our business affect it? It's a complex question. I'll try to give you a lightning round answer. In short, if you look at the trends in regulation over the past 8 years, there's been this myth, or half-myth, that there is a crackdown in IT in terms of national security. I'd like to also add, and it was mentioned by Mr. Drozdov, that the COE at Skolkovo had prepared dozens of legal documents, legislative documents for digital economy, as well as hundreds of amendments to existing laws in IT that were proposed by regulators to ensure our sovereignty. This difference in scope, I think, doesn't have to do with an ostensible desire to be protective more rather than conducive of development. I think it speaks to the openness of the regulators to innovate in their domain. Some laws are broadly applicable. They are impactful, but enforcement is scarce, the actual practice. So I'd like to call upon young researchers and young lawyers who are not yet PhDs or full professors, to be more innovative, to ideate. We don't have time to replicate the practices from other countries, to copy their models. We need to learn as we go along. Just like ChatGPT, there needs to be a proper prompt or a request that translates into new formats. There is this example that we haven't been able to gain appropriate pace, even if the unfriendly actions by the West had been known quite some time before 2022. In 2016, the Registry of Russian-made software was established and mandated in procurement for public authorities and state-owned corporations. There were other things that were debated, SWIFT and transaction infrastructure was discussed a lot. But still, we haven't been able to apply that innovative legal framework. And the audience today, the young audience today, has every opportunity to make their contribution into our near future. One thing to the point, I'm sorry. Apologies, Mr. Shelton, but in the agenda, there is a very important moment that we cannot bypass. The graduates of the institute came up with an initiative to set up an alumni association. The director, Ms. Khabrieva, has supported it. Meaning that now we'd like to present the certificates of membership to our friends and guests. A great initiative. Apologies once again. Maybe we can go on with the next question. Or let the speaker finish. Well, lawyers are known to be sticklers in terms of timing. So, a very small point. A lot of IT companies who are interested in development in Russia have been lacking appropriate legal frameworks to set up their new logistical models. Even if most of the world is in support of Russia and Russian projects, the entirety of the world, which is not Anglo-Saxon, and half of Europe to boot, are on our side. There haven't been enough regulatory frameworks or legal frameworks, which is the reason now why certain projects migrate to the neighboring countries, to ICIS, to the UAE. I think it's a challenge to the new generation to build this platform for our country. Thank you for your response. My next question is addressed to two of our panelists. The question is this. Mr. Shelton, Mr. Yankovsky, in your opinion, do we need any fundamental changes to the fourth part of the civil code, the most recent part? And is there a future for digital entrepreneurship in Russia? It's something that's widely discussed now. Mr. Yankovsky, please. Well, I'll delegate the question on digital entrepreneurship to my colleague, and I'll speak to the fourth part of the civil code. It's been discussed for a long time. It started in 2016, as far as I remember. Digital rights, cryptocurrencies, and crypto assets that need regulation. There were discussions that intangible, non-derogable rights needed to be introduced to cover objects in computer games, cover domain names, and a host of other things. In theory, we already have a number of provisions that have been designed and drafted. There are monographs to give theoretical support or scaffolding to this. So we are ready to start implementing these ideas into the civil code. But then we need the legislature to be receptive. Thank you for this. Well, unfortunately, I'm not a lawyer to give you a qualified professional answer. But as a future PhD in technical sciences, as an IT entrepreneur, I think I can quote our president. There is no time to ramp up. The sectors of the economy that can generate additional revenues, but are not doing that, is a challenge. So digital opportunities, revamping of logistics within the country and outside the country, new formats, all of this needs to be advanced with regulatory sandboxes so that we create new opportunities for development. existing innovative businesses, many of those have cropped up over the past year, need to have the hurdles that they face eliminated. Thank you very much, colleagues. Thank you for sharing your experience and your vision of the future. This concludes the first plenary. Thank you. Colleagues, let me now invite on stage the panelists of the second plenary. We have Piotr Kucherenko, State Secretary, Deputy Minister of Science and Higher Education, full professor in law. Then Valery Frolov, Pavel Volkov, State Secretary, Deputy Minister for the Development of the Far East and the Arctic, Yuri Lyubimov, First Deputy Director of Rushydro, Alexei Sapetko, Director of the Department of International Cooperation of the Ministry of Transport, and Vitaly Kluyev, Director of the Department of State Policy in Sea and Inland Water Transport of the Ministry of Transport. During our second plenary, I'll have as co-moderator Sergei Sinitsyn, Deputy Director of the Institute, full professor of the law, and a professor of the Russian Academy of Sciences. Hello, colleagues. I'm not going to give you a report, but rather co-facilitate this discussion. The second plenary. We have very interesting speakers today. They have first-hand experience in current regulation and current needs in the area of law, both in theory and in practice. It's a great opportunity to ask questions to a young deputy of the head of the Russian Federal Service for Intellectual Property, Mr. Frolov. Do young inventors actually have access to securing their IP rights? It's a very important question about protections that's on the mind of younger people, because they generate a lot of ideas, a lot of technical innovations. We'd also like to learn about the number of young inventors that you're seeing today. Thank you for this question. Hello, colleagues. I think my question is going to be pretty straightforward. Creativity is available to all ages, so there are no limits in this regard. If you need to register the products of your creative activity or thought creativity, formally, you can file your submission to our agency starting from 14 years of age, provided there is a consent by the guardian, that is parental consent. There are preferential terms on state service fees for young inventors as well. Formally, this is pretty much it. Now on to the state policy in support of youth entrepreneurship and young researchers. As the Federal Agency for Intellectual Property, we hold a lot of events in partnership with Sirius, with consortiums. We've signed a number of MOUs with such advanced schools. Our federal agency cooperates with the agencies that we supervise to carry out International Olympiad in intellectual property. It's well attended, it's high level, and it's supported by the European IP Agency and by the World Intellectual Property Organization. On a larger scale, I can give you a most recent example where the government initiated a championship in robotics. I think it's going to take place this year. Thank you very much for this input. Should be interesting for young lawyers and young researchers. With that, I'd like to ask the next question to Mr. Volkov. The question is this: are there plans to ramp up the mechanisms for attracting young people to the Russian Far East and to the Arctic in order to pursue the strategic goals of our state? And then, is there any relation to the bill on artisanal mining that's been discussed recently? Then, another part of the question is whether there is a need to develop new types of entrepreneurship in the Arctic and the Russian Far East. Thank you. Hello, everybody. I'm glad that such events are taking place. Thank you for the invitation. Thank you for this opportunity to cross-pollinate with great ideas and to really gain some insights. I don't have much time, unfortunately. I'd like to visit other sessions of the forum as well, because I sense that it's a place where there is a lot of novelty in the air, given that there are a lot of young researchers among the attendees. If the timing allows, I'll take 5 minutes, no more than that, to tell you what we're doing in the Russian Far East. Maybe some young researchers would then want to apply their skills, knowledge, and future experience in the Russian Far East. As you well know, there is this project for advanced development in the Russian Far East and in the Arctic, one of the national ideas announced by the president. But as lawyers, you have an understanding of our governance system is structured. In 2012, a ministry was set up to address the long-standing issues of that area that we call the Russian Far East. It actually takes up over 40% of the entire land area of our country, whereas it only accounts for around 5% of the funds in the consolidated budget of the country. To provide an impetus to tap the potential of that area, new things are needed. So the ministry was set up with 3 functions in its mandate, everything that they could come up with at the time. So this was managing public property, coordination of other executive programs in the area, and the third function was oversight of delegated authorities. And that was all that the initiators came up with within our governance system, which is industry and sector-based, as you'd know. After a year, it became clear, painfully clear, that the ministry was not managing to address its tasks. The president took a drastically new approach The ministry was reshuffled, the team was replaced. Mr. Trutnev was given this responsibility in his two roles as deputy chair of the government and representative plenipotentiary of the president in the Russian Far East. The ministry had its mandate expanded, development institutions were set up so that advanced priority development of the area can fully take place. What were our first steps? That's an obvious question. And this would be a completely new economic environment, because this is how you advance towards social improvements. And in order to achieve that, the Russian Far East needed to attract new companies and to modernize its business community. When Siberia had its economic boom, the Russian Far East was lagging behind and relied on logistics and some isolated industrial clusters. We have aircraft building, other advanced manufacturing plants, but mostly this is mineral extraction with very low value added. So it was decided to come up with preferential legal frameworks in the area. You heard about them. Priority development areas, Vladivostok Freeport, the Arctic territory, which segues into the expansion of our mandate. The Arctic area is separate. There is the special economic zone in the Kurils Islands. Bottom line is that entrepreneurial risks need to be minimized. That is our key focus. The Russian Far East needs to be very accommodating to all entrepreneurial initiatives. The rationale behind this and the way we've approached it, is pretty clear, because sometimes, as you read the legislation, you get the sense that people who wrote it never went outside of Moscow. Sometimes you'd even think that it was written by hidden enemies. Locally, solutions would appear completely different. Like, take an old geezer who does some fishing. Does that old person really need to go to Moscow to get his license? And imagine what they think of the government then. So these are technical hurdles that we put in place ourselves, and now we are working on eliminating them. That's the bulk of our activity now. And we want to attract as many projects to Russian Far East as possible, even if it's complicated. There are challenges in social well-being, for example. It's a part of life that is a factor when you decide on moving. I think in the audience there are some people who've come from the Russian Far East. A show of hands? No one? Really? Well, there are some, and I think that some are closeted migrants. Because you've seen, right, the development of the economy and social safety nets around here and there. It's a great pain for us who work on the development of the Russian Far East. We have budget constraints, so we are limited in what we can do, but still it is a priority. We address it not only through the betterment of the business environment, but also through public investments. We do a lot of lobbying on behalf of our regions. That is, to get allocations in national programs for kindergartens and other social things. Again, our governors once went to the president and showed him the formulae used to calculate the allocations in the national programs. And the outcome would be that the Russian Far East was never getting a single penny, only if there were some scraps left. This used to be the paradigm, but now we've bucked the trend, and it's all coming alive. The question was about most recent developments, because I feel that I need to wrap it up. I could talk hours on end about it. Our current focus is on continuous improvement. Because we need to remain competitive. Best practices are shared, so you need to keep up. Some countries have been closed as destinations, but international cooperation with friendly countries is one of our efforts. We are working on setting up international priority development areas to attract people from these countries, people and companies. We use preferential terms and benefits in order to drive the development of industrial clusters. The second priority is tourism. As I mentioned, it used to be a commodities region, all mining and all exports, but there is a boom in domestic tourism. As we speak, it's one of the national ideas in Russia which finds fertile ground in the Russian Far East. I think you'd be willing to go to Kamchatka. I'm not asking you to, because it's a process. We are setting up the infrastructure together with the federal government. Over the many years, this hadn't been done. Why is a separate question, but we need more high-quality accommodation, convenient food outlets to all levels of income, and a whole bunch of other amenities. Another thing that might surprise you, but it's still relevant, a throwback to history in a way. We had this period. There were 40,000 artisanal miners in our country. This was under Stalin, and artisanal mining co-ops produced the most gold in the country. You are better experts on the subsoil legislation than me, probably, but bottom line is that artisanal mining as an institution to supplement larger corporations was neglected. Larger deposits that generate returns for larger companies are being developed. There are bidders, there are competitive procedures, but then you have tailings once it's depleted. Some deposits do not yield attractive industrial returns. And you'd be wrong to think that nobody is tending to these assets. These are illicit miners who are on it and very actively in cahoots with organized crime, sometimes ethnically based. They reap all the benefits without paying a single ruble into the state coffers. So another of our priorities is to make this a win-win for artisanal miners and the government. Currently, the situation is that for them, to operate is to strike a deal with organized crime and sell their product for nothing. We want the legal regime for this to be as simple as possible, and it should be innovative. The first session was about intelligence, right? We have the Russian Far East homestead. You can get a whole hectare. It's available on your smartphone. If you team up as a family, you can get up to 10 hectares of land. It's mapped out together with the Rosreestr agency in order to enable proper gold mining in the Russian Far East. And you don't need to dig for a license, if you pardon the pun. It should be really streamlined. The contract is generated automatically, can be signed on the government services portal. I'm putting it in very simple terms, but it's not simple by far. It's very Dickensian. There is a lot of minutiae to be addressed. And I don't think it's an area for young researchers, but still very interesting. Look it up. We'd appreciate your feedback a lot. Once again, thank you for the invitation. A great event. Thank you to the Skolkovo Foundation as well. So, appreciate the invitation. Once again, everybody is welcome in the Russian Far East. Thank you. Thank you, Mr. Volkov, for this sizable input. Thank you for food for thought and for your analysis. No doubt this is relevant for the younger people in the audience. Next, I'd like to give the floor to our next panelist, Yuri Lyubimov. You've worked at the Ministry of Justice for many years and in the Ministry of Economic Development. I would like to specially note that Mr. Lyubimov is now First Deputy Director General of Rushydro. So, what I'd like to throw at you is this question. Was there any impact from the inputs by the younger people in terms of driving clean energy and addressing energy and environmental issues in Russia? Are there any new dimensions for development in these areas or for public-private partnerships? Thank you very much. Our company, being from the Russian Far East, is very vulnerable, especially following on the Deputy Minister's presentation. Our company is called Rushydro, Russian Hydro Energy, right? And that was the original idea. Our headcount is 70,000 people. How many do you think work in hydraulic energy? I think it's 500 people, including the headquarters in Moscow, whereas 65,000 come from a company that was merged with us. That is RAO Energy Systems of the East. So we are more of a Far Eastern company than of a hydroelectric company, whereas, of course, we prefer to be hydro energy more. Still, I'd like to thank Ms. Habrieva personally and Mr. Drozdov, my groupmate, by the way. Our friendship goes back to the uni. We started out as young researchers together. He became the young researcher, and I'm no longer young and no scientist, so I ended up in an energy company. Still, thank you very much to speak in this magnificent hall. I think I visited this venue when it was an open pit under the snow, way back when. It's been built up really nicely. Once again, thank you for the opportunity to speak to young researchers. The moderator asked me about clean energy. You can't even begin to imagine how many clean energy we as a nation can produce. The cleanest energy, we believe, comes from water. It's not the cleanest, but also the cheapest. The particular feature of hydro energy is that it's front-loaded. A lot of investment goes into a huge dam, into setting up the reservoir that ensures its operation. But then, for many years to come, it gives you dirt cheap energy for a century or more, hundreds of years. So, hydraulic energy requires a lot of upfront investment. Looking at Europe, they are very active in solar and wind energy, but it's not because they're privileged. The reason for that is that their hydraulic energy capacity has been exhausted, pretty much, even if they'd like to use it. They've used 90% of their potential, whereas Russia has only used 15%. So it doesn't make sense for us to make a push for solar and wind. It's more expensive. Once all the rivers are dammed up, including the Moscow River and others, then maybe we could consider solar and wind. Wind and solar are great in their own, they're clean, and there are countries where it makes more sense. But not in Russia. We have such untapped potential for hydro that we can redouble it or multiply it 6 times, still have some for change. I've read the agenda, and it was asked to give a few words to young researchers, right, Ms. Khabrieva? I don't think you're interested in what we're doing, but it would be much more interesting for you to hear about what we need from you. Any scientist is by definition a young researcher or an old one. If you're young, you still have the energy to actually pursue scientific ends. Once you've become disillusioned, you wouldn't find the time or energy, you'd be lazy. So while you have the passion flowing in your veins, do write something to leave a mark in science and on paper, preferably. Secondly, I believe that one of the core issues in the legal profession for many years, in the public sector and in the private sector, has been that we are understaffed. This might sound surprising, but it is true. There aren't enough candidates out there. As a nation, we are keen on learning, and we keep doing it without thinking, oftentimes. A lot of young non-researchers, by the time they're 30, still don't know why they had received their diploma or in the specialization or the major that they've chosen. And it's an ailment of us as a country that getting a second diploma is a scourge, actually. I believe that if you have a second diploma, this means that your first choice was flawed, and you need to review your choices critically. As a person who has been an employer in all shapes and forms for many years, there is a shortage of sharp-witted, independent people who can generate ideas and implement them. The ratio is 100, one person to 100. Well, realistically, it's 10% of candidates where you can discuss anything. The second problem that I see is soul searching, to put it mildly. There is a candidate, 25 years old, and they've hopped between 8 jobs by then. And you ask them, like, your career is 9 months old. Why 9 jobs? And they reply that they were soul searching, 2 weeks here, 3 weeks there. a month and a half there. Another job was to my liking. I stayed there for 2 months, but I got sacked. The company got liquidated and I wasn't notified. In my next question, my follow-up, very cynical, is why would we, as an employer, want to fund your soul searching? Because candidates believe sincerely that we are there to pay for their quest of self-discovery, whereas companies don't need that. So you need to decide on your specialization as a researcher or as a candidate on the job market. And my first question to anybody is, where do you see yourself in 10 years? If there is no answer, then I think there isn't much to go from there. The only person who can not have a reply is a pretty young lady who expects to get married and birth 8 children, and might be shy, a bit too shy to put it straightforwardly. Any other person must have an answer for that. As for the current state of affairs, there is this trend that I'm seeing. We are living through an unstable time, emotionally unstable. And the situation gives rise to 3 processes that are of interest. First, it's a time of slogans. There are a lot of people who call upon everybody to do that, to do this, but as lawyers, we need to tend to the stability of regulation. And the Institute has been carrying out this mission with great honor and dignity for many years. Together with Ms. Hambrieva, we stood up for things that ought to be stable. If the times are unstable, you shouldn't touch the fundamentals, especially in private law. Look at the companies. The regulation is founded in this sense of stability. Our revenue is $500 billion, and our investment program is almost $1 trillion. But we wouldn't invest if we don't have clarity on our rights and title several years ahead. We need to be clear on the returns, at least 5 years ahead. We need to be clear on the payback. If we don't know what our title would be, we wouldn't invest. I think this is legal 101, but people often forget about it. Secondly, there is a precedent for anything. Faced with an unstable, emotionally unstable situation, people tend to think that this is unprecedented. But that's not true. Armed conflicts, sanctions, trade embargoes. History has a plethora of examples of that. And as researchers, you can dig it up. Look at the many wars that had happened across all continents. You'll see all the same mechanisms that have been used throughout history for hundreds of times, as well as the response measures. So you don't need to reinvent the wheel every time. My third point, you see the implication of living in these challenging, troubled times is that we've begun to open for us and learn about the rest of the world. As I was a student, we referred to the same legal schools, a few legal schools, the Anglo-Saxon school, and now we are finding out about other countries in the world, and there are almost 200 of them, actually. And a lot of them are economic powerhouses. They have their own well-established legal systems that are quite interesting. And they are now used in international deals, in structuring of holdings, assets, settlements. These things are now used more actively. And it's a whole new ground for research. to investigate legal systems that are out there in the countries that we have discarded so far. Just try and look up something on the legal systems in the countries where we are working, operating, or trading actively now. The Emirates, Turkey, China. This is going to be a paper and a half, usually written by an exchange student from that country. A huge field of research that hasn't been dealt with. Just recently, I discovered Uzbekistan, for example, and I'd never think that I'd visit. A very interesting country, very dynamic, colorful, and you can sense it in the air that it's developing really fast. But do we have researchers who are studying the legal practice in Uzbekistan? I don't think that there are many. Apart from the institute, of course. I'm speaking about the young generation in general. But it's a Russian-speaking country. There are chapters of our major universities there, a lot of Russian literature, but it's still under-researched. And then in closing, what else is there? Something from me to the younger generation. We talk a lot about AI, breakthrough technologies, and so on. But then, in the end, it's down to people. Sharp-witted talent is always in demand. And if you want to go into energy, you're welcome. Through the Institute, I think we can set up a kind of program together. We are always open to good candidates, so we can promise good career prospects. I recently learned that we have more than 800 legal counsels in our group, several hundred of property managers, so there is a lot to do and to find yourself here. But it's important for you to understand the practical dimension of your research from the outset. There are a lot of jobs to be done. It's just about your choice. Ms. Habriba, thank you once again for giving me the floor. Thank you, Mr. Lyubimov, for your remarks, for your well wishes, and for being very much to the point. Now I think we'd like to hear something about the prospects of legislative development in IP. And I think we can frame it to be interesting for the younger generation, because they are the pioneers of innovation and invention. They hold the keys to the future. One of the most urgent issues asked about by our audience is this: how to commercialize the intellectual property that you have and how to value it adequately. I'd like to ask this of Mr. Frolov, Deputy Head of the Federal Service for Intellectual Property. Thank you for this interesting question. Indeed, it's very relevant, and I think it merits a bit of a backgrounder. We usually think of intellectual property or patents as a safeguard for your rights. But you need to look at it also as an object of trade, an investable asset. There are a lot of measures that are being taken to support this currently. Intellectual property can be an asset on the one hand, and on the other, you need to qualify by 3 criteria: novelty, industrial feasibility, and the level of invention. So once you get the title of protection, it is a confirmation that this idea that's patented has some commercial potential. So you need to be careful with proper registration of your rights timely identification and swift commercialization. What can be done to this end? Economically, in the accounting dimension, these are intangible assets. They can be entered into your balance, which is an additional capital infusion for your equity, which kicks off a whole sequence of events. Your capitalization helps you raise funds, raise finance, which then translates into further technical development, more new ideas that can in turn be commercialized and scaled up based on the original idea if we're speaking about a smaller startup. In this regard, I think it is important to note that as you commercialize your IP, there are supports by the government for small businesses. If you are to license your intellectual property or to assign it, you can be entitled to certain taxation preferences. We've set up the patent box as a regime where Russian regions can set lower taxes, lower profit taxes applied to deals of this sort, licensing and assignment. And then there is the issue of identification. There are profit tax benefits as well, where you can retroactively enter intellectual property assets into your balance without incurring profit tax, so that they are commercialized successfully. Thank you. And to follow up on the questions that we've touched upon, the products of thought process that derive from AI, does this require special protections? Who is going to be the copyright holder of an invention or a IP of some other sort? Who is going to be the rights holder? Can you comment on that? Because it's relevant not just for the younger people, but for older inventors as well. A lot is being done by your agency as well to digitize the registries, to implement digital technologies. Let's take filing. A lot has been streamlined. So, title of protection are no longer certificates, but entries in the registry. It's all very interesting and useful, but is there a risk of a gap emerging between younger and older generations who, frankly, are not as digitally savvy in some cases? Here are my two follow-up questions. Again, asked about very much, so I'm relaying the questions to you. That is true. The fast-paced development of digital technologies and digital processes over the past decade has brought some novelty into the legal profession as well. The legislation and the practice are mostly conservative in this regard, and it was mentioned today already. The law is there to govern social relations. Insofar as the role of AI is not defined in these relations, the law is going to continue focusing on the person, the living person. So, legal personality of AI is still not established. Just recently, there was a conference held by the World Intellectual Property Organization that addressed the development of legislation for metaverses and AI. It was exchange of good practices and experience, and I can say that there isn't a single country globally that has established legal personality for AI. As for future developments in legal practice, there are indeed a lot of benefits from digital technologies. Look at metaverses, for example, digital spaces where relations need to be governed as well. There are inventors and researchers as well. It's a platform for communication, which facilitates production of IPs. Our system needs to be client-centric to accommodate protection of rights in this new environment and timely commercialization as well. Let me give you an example from actual practice. A number of metaverses has been launched, and there is this pressing issue of regulation of trademarks in these digital spaces. In the digital environment, it's just a picture that can be easily copied and pasted. There are a lot of unresolved issues like that, but to address your question directly, where you asked about digital inequality, at least that's the way I heard it, inequality between the generations in the digital age. I have to reiterate that our legal system gives a clear-cut answer to that. The digital space in the government services is not exclusive. We are not limiting ourselves to that, and we offer all channels possible to interact with us. As the agency, you can submit your filing on paper or on a CD even, if it's a computer software. If you wish, you can do it like that. There is a fully digital channel as well, but you can do as you like. The expert reviews and registration can be done both ways. We continue our development, and we want to build an ecosystem of IP. We engage with the business community, we get involved in PPPs, we are developing analytical platforms, we work closely with the Russian Center of Intellectual Property to set up an exchange for intellectual property rights. We try to do more than just provide a government service. We want to streamline the customer journey for inventors, for them in order to get the title and to ensure commercialization. Thank you very much. Colleagues, the plenary today, or the two sessions that it's comprised of, is also about careers in the legal profession. Great opportunity to get a knack of what's it all about from the leading experts in Russia who are taking part in this school, willing to share their experience and knowledge. Let's switch on to the next rubric that has to do with the transport legislation and its development. It's at the forefront of technological development. There are a lot of driverless and autonomous vehicles cropping up now that do more than just transportation. With that, I'd like to introduce our other two speakers, two directors of leading departments at the Russian Ministry of Transport. Alexei Saptenko, Director of the Department of International Cooperation, and Vitaly Kluyev, Director of the Department of the State Policy in Sea and Inland Water Transport. In this context, my question is this. It's about autonomous vehicles, their legal status, and how the legal framework or policy has been changing. What are the risks and opportunities that are arising now? What are the current objectives of regulation in this area? Let me start with Mr. Saptenko and Mr. Kluyev together. Let me give the floor to Mr. Sapetko first, because it's really narrowly phrased. Sure, thank you. Thank you for the invitation. Thank you to the Institute for the opportunity to take part in this interesting forum. I represent sea and inland water transport. But before I go into the prospects of regulation in autonomous seacraft or watercraft, I'd like to counter a point by one of the previous speakers who said that getting a second diploma means that the first one was in vain. I just got my third diploma 2 months ago, a master in jurisprudence, and the previous two are I am a navigation engineer and an expert in international affairs. So none of this was in vain. I know for sure what a craft is, where the mast pole, keel, forward bow, or stern frame. And I know with certainty what international relations are, agreements, and such. Through the scientific lens, I am a lawyer now as well. 2 months since, I have insight into the legal science, and it enables me. I never mentioned a third diploma. Okay, so 3 is fine, as well as the 4th. Okay, I hear you. So, autonomous crafts. Let me give you a story from the 1978. A German magazine published a whole issue called Watercraft and Navigation of the Future. There is a whole article that discussed autonomous watercrafts in the 70s. And their forecast was that captain would die off as a profession, and watercraft would be operated and navigated by automated devices on board or on land. And they are already considering potential regulations to support that. It was put on the back burner for a long time, but then in 2017, quite a while after, the International Maritime Organization began discussing the technical advancements for the first time that were already trialed back then. That would be a watercraft without a crew. Maritime law is very special. Sea transport is one of the more international types of transport, and the secretary of the IMO mentions that it supports more than 70% of international trade. The secretary also said that if there is no marine traffic, half of the planet would die of exposure to cold because they wouldn't get fuel, and the other half would die of hunger because they wouldn't get the food supplies. So it's hard to overestimate the importance of sea transport. Experiments with autonomous craft are gaining steam, but all of the law of the sea was based on the fundamental principle that a vessel, a craft, must be crewed, including a captain. And the Bible of the maritime law, the Convention on the Law of the Sea, provides for each craft to have a crew and a captain to operate the vessel, and they must be appropriately qualified. There are more than 50 significant binding international instruments to support that under the aegis of the IMO. In Russia, there is a merchant shipping code that regulates it on the national level, and it's integrated into the international maritime law. But then you get a craft where there is no crew. How do you regulate that? The IMO began discussions on this, and in 2017, yours truly published an article, a first of its kind in Russia, that proposed the idea of national regulation for autonomous craft, laying out the key aspects. There was a draft bill for a federal law that would amend the Merchant Shipping Code of Russia and other pieces of legislation. It takes into account existing international regulations and tries to articulate national approaches that would not contradict the international norms. Given the opportunity, I'd like to extend my thanks to the Institute of Legislation and Comparative Law, because the original draft was well received by the Institute, and I'd like to especially thank Mr. Kabirov for your original feedback, which actually made that bill viable. But then there are a lot of academic issues, legal issues, not technical in terms of devices and configuration, but legal issues on how to actually regulate these relations. In the end, the current status is that that bill was submitted to the parliament. It passed first reading, and hopefully it will be enacted during this session. Another point I wanted to highlight is that our national efforts to regulate autonomous watercraft were escalated to the IMO and had significant bearing on their deliberations there. They are developing a mandatory code on operation of autonomous craft that is based on our ideas up to 60%. The idea to introduce national legislation was well received by the national community, and I can say confidently that we are ahead of the curve internationally. But it comes with challenges. There are no examples to draw from. There is no international agreement that would enable us to implement its provisions into our law. It's in reverse. We articulate the principles and approaches that are then escalated into an international agreement. The ideas that we proposed that inform our bill and that were received by the IMO are this. The first idea is a remote crew. There is this feature in the Convention on the Law of the Sea that it never mentions that the crew needs to be physically present on board. It was well received universally, and this translated into this concept of a remote crew. The provisions are being discussed now. This remote crew would be on board another vessel or on land and operating that craft remotely. The second idea was that of full functional equivalency, meaning that we do not amend existing regulations, but propose new norms to govern autonomous craft without amending the law that has been in the making for more than 100 years. This full equivalency for unmanned craft to crewed craft has been well received by the national community, and it is part of the discussions at the IMO. The third idea was quite challenging to elaborate. It has to do with responsibilities, obligations, and liability. It resonates with what has been discussed with AI. And AI on an autonomous craft is a whole separate can of worms. But we've been able to come up with a formula where we do not contradict the existing norms, where the key person responsible is the ship operator, who actually uses it regardless of ownership. That's the key party who bears the responsibility. But then, if there are any flaws in the software or in the hardware, needs to be appropriately divided across the vendors, software or hardware vendors as well. The devices that enable autonomous operation. Last but not least, there is one other idea, and the bill, and also discussed internationally, is potentially setting up specialized organizations that focus on operation of autonomous craft. Dedicated legal entities that have on staff these remote crews and have the skill sets to do that. There are a lot of other details, but I'll gloss over them in the interest of time. I'd like to mention that it's a unique situation where technology is advancing in tandem with the law, because originally we were told that let's wait for the technology to get mature and then we'll implement the laws. But it's a catch-22 situation. Should you have this type of craft, you wouldn't be able to operate it because there is no law, and then there is no law because there is no autonomous craft. Thank you to the Institute, by the way, for resolving these hang-ups. There are technical experiments. 3 Russian craft are being piloted, trialed currently, and 2 more are to come. Whereas in parallel, we are designing the regulations to support their operation. My last point, if I may. Sure. I wanted to touch upon creativity, drawing from the previous session. It was mentioned that there is no space for creativity in law because lawyers are sticklers to the rules, and should be. I think that coming up with new regulations is a creative job, and we have job openings if you are interested to join the Ministry of Transport, because designing new legislation is a great opportunity. And it's especially challenging to find people who are creative in maritime law. Russia doesn't have schools of maritime law. Globally there are, but we are lagging behind here. Private law is well studied and taught. There are experts in corporations, but public maritime law doesn't receive the proper attention in terms of education. So welcome on board if you're willing. Thank you. Thank you very much. I'd like to give the floor to Mr. Kluyev now. Autonomous watercraft or aircraft, indeed a very relevant topic. Sure, with pleasure. I like to speak last, because you're clear on the timing, or lack thereof, and then you can draw or rely on what has been said or has been omitted by the colleagues during the first panel or the second panel. Thank you for your inputs, because you are one of the heavyweights. Thank you to Mr. Spetko, because maritime law is heavily regulated in a good way. Indeed, it is cutting edge in terms of all innovations, not only autonomous vehicles or craft. I'd like to draw a bridge to transport overall and to international affairs in transport. Examples that were given by these catch-22 situations and regulation, you face them all over. It's not only about maritime law. The same applies to air transport, because these domains are regulated by international conventions mostly. You have ICAO in the UN, you have the Chicago Convention on International Civil Aviation, as well as a plethora of multilateral agreements that are signed, implemented, or observed by most of the countries. There isn't a single approach yet, and indeed it is room for great work by practicing and theoretical lawyers. You can indeed contribute personally to laying the foundation of new regulatory approaches to these new areas that are only emerging. We spoke a lot about AI during the first session. One of its applications is indeed self-driving or autonomous vehicles. There can be two types of those. Autonomous vehicles where there is no driver at all, or there is a driver on board, but they do not operate the vehicle. Different levels of autonomy on the road, various unmanned flying vehicles are also part of this. It applies less to rail transport because, well, there is just one way to go along the rail, but still there are features that put forth requirements that need to be observed. Mostly this has to do with urban transport, light rail and underground. And then you have virtual coupling, for example, in freight traffic on the rail. I'm trying to give you a bullet point view of what's there in the industry to kind of elevate our discussion and give you a sense of the room for creativity by lawyers. It's insurmountable. It's a lot, and there is a lot to be done. As a tool, we can rely on conceptual ideas. We can run sandboxes limited to certain geographies to run trials. As technology is developing and as legislation is developing, we'll be able to set up pilot projects. You've probably heard about autonomous projects for cargo vehicles between Moscow and St. Petersburg. I think that by the end of this year, there are going to be the first instances of these vehicles on the road, together with the rest of the drivers. I think you wouldn't be able to recognize them on the outside, but we'll hear in the news that there were such trips without a driver. And it's going to be more and more. It's another layer, because after sandboxing, you come up with practical solutions that are now scalable. And we are in competition, racing with our still partners in the West in this particular domain and in the East, who's going to be the first to come up with the standards and regulations, because this country is going to be the trendsetter and will be able to impose their approaches and regulations, including in controversial topics. We work closely with our Chinese colleagues to set up autonomous corridors in the Russian Far East, and it's going to be a joint sandbox. We do both, technology in terms of integration of infrastructure, hardware, radio frequencies, software, because there are a lot of parameters that need to be aligned. At the same time, we are trying to harmonize our regulation. You know, our big partner to the big neighbor to the east has a very different legal system, which brings us back to this point about these practices being under-researched dramatically. And this concerns the former Soviet republics, as well as more remote, but still very significant countries. So colleagues, once again, I think we can show our cards by now. It's not just a practice call, it's a career day as well, an opportunity for different government agencies and corporations to showcase some of their activities that are not evident, to show that they have some room for creativity, some areas where you can add value and tap your potential, truly leverage your diploma, or decide on your secondary education. By the way, I'm not a lawyer. I'm an international affairs guy, but as any member of my profession, I'm a bit of a lawyer, which applies the other way around as well. Without understanding of international regulations, it's hard to stay within your closed loop. So do come to us. You'll see how complex transport is, and you'll see that we live in interesting times, which makes us different from the Chinese. They dread interesting times, whereas we see it as an opportunity, a window into the future, much larger window than Peter the Great once laid through to Europe. Autonomous vehicles, unmanned vehicles, these are not the sole challenges that we faced recently, because last year, a whole bunch of international regulations became invalid. For example, flights were denied just overnight, and this is a violation of numerous agreements and arrangements internationally without any prior negotiation or conditions. It just stopped working. It's a whole new world, a new paradigm where if there is a will, you can be denied anything. Any agreement can be sent down the drain. We are taking this into account, and with any new foundation or project, we try to make it self-sufficient. What provisions need to be done, what safeguards need to be put in place for ourselves, for the investments, for the partners, for the IP as well, assets and so on and so forth. Transportation is well grounded as an industry. In Europe, they call it, or internationally, they call it TTE, telecoms, transport and energy. It's infrastructure heavy, it's complex, it's interdependent, it's integrated. It cannot be operated without harmonization of regulations, which makes it ever more interesting. I'll be glad to take any additional questions, so I don't think we need a deep dive on regulation. But then you have the EAU, the CIS, bilateral agreements, bilateral relations that used to be friendly or not. We have a lot of new opportunities with new friends. The geography of our efforts is being turned upside down. We used to work on our transit potential. It is no longer the case, but it's not gone. The potential is different. Imports and exports are now the focus. So now we are looking at it as an alternative to new trade destinations. And there is a lot for lawyers to do, so I'll be glad to see younger faces in our ranks. I don't quite agree with soul-searching, the point that you made, but maybe it's important as well. I think you need to at least try to work in your specialization. If you do not go to work under your major, this is a red flag. If you at least tried, I think it's just happenstance. Maybe you'll succeed. Thank you for the invitation. I'm glad to see the young faces here. Thank you. Thank you, colleagues. You know, it's all passed in an eye blink. 2 plenary sessions are over. We've exhausted our agenda. With that, I invite you to the photo op. And after the break, we'll have 2 more sessions. Breakouts, where in this room you'll be speaking about the faces of law and the legends of Russian legal scholarship. You are kindly invited. See you after the break.